Welcome to Property Law 101. I'm Sara Bronin, and I created this series to help you understand the basics of property law. We cover 4 questions in the series, and today we are talking about the 4th, which is holding interests in property. Leases are among the most common way to hold an interest in property. What some tenants may not have heard of, though, is the covenant of quiet enjoyment. This traditional common law concept used by all jurisdictions today means that the landlord cannot substantially interfere with the tenant's use or enjoyment of the leased premises. That covenant is tied to the concept of a constructive eviction. So we all know what an eviction is. That's an affirmative act by the landlord to remove a tenant from the premises. A formal eviction goes through the courts. A constructive eviction is different. It does not involve the landlord saying, "I wish to evict you." It occurs when the landlord's actions or omissions render the premises substantially unsuitable for the purpose for which they are leased, or where they seriously interfere with the beneficial enjoyment of the premises. So, whether the covenant has been breached by a landlord usually hinges on the question of whether their interference was substantial. Residential landlords may have the obligation to maintain a fit and habitable apartment. So, an apartment, for example, without water would be seen to be a constructive eviction by the landlord because not having water is a pretty substantial infringement on the right to quiet enjoyment. You can also have a constructive eviction even where you don't have a violation of the housing code, a matter that is discussed in the video about the implied warranty of habitability. An example of a constructive eviction in a commercial context might be that where a landlord leases a building to many different users, the landlord puts a day spa next to a children's daycare center. The noise of the daycare center is incompatible with the serenity required by the operators of the day spa. So in extreme circumstances, and there have been cases with this exact scenario, the landlord could be charged with constructive eviction in a commercial context. Similarly, in either residential or commercial context, if the landlord does not give the tenant access to all of the premises that were leased, then that is at least a partial constructive eviction. So what happens if a landlord violates the covenant of quiet enjoyment? In extreme circumstances, the tenant has the ultimate power of breaking the lease without penalty. The tenant can also withhold rent. In those scenarios, the tenant has to move out within a reasonable time period. The tenant may also have the ability to sue for damages, including the cost of moving. For businesses, damages may also include the foregone goodwill accrued by operating in a particular location, as well as damage to the reputation of the business when unhappy day spa customers are serenaded by Ring Around the Rosie during a body scrub. The covenant of quiet enjoyment is an important protection for tenants. So I'm just going to leave it there. I'd love to hear from you, whether on Twitter or through my website, where you can sign up to my mailing list, and I will see you next time.